Well, good evening, ladies and gentlemen. Good evening, listeners from India as well as America and all over the world. This is Mridupal Bhattacharya, and we are back with season 2, episode 2 of AI Now. So, we have with us today Mr. J.L. Himes and Mr. Ron Schnell. Give a brief introduction about them. So, Mr. J.L. Himes has been at Lebanon, Shukero for the last 12 years and was appointed by the United States District Judge Oric to serve as the monitoring trustee under the final judgment in United States versus America versus Bazaar. The recipient of 2014 William T. Liflin Service Award presented by the Antitrust Law Section of the New York State Bar Association for distinguished service to the section and the legal profession. He has served as the Antitrust Bureau Chief in the New York Attorney General's office for nearly 8 years, leading significant high profile antitrust investigations and enforcement actions. The state's principal representative in the marathon negotiations that have led to
Lost contact. Is that me only?
No.
Oh, well, I apologize for that disconnect. I believe he'll be back soon. Hello, everybody, and thank you so much for being here. My name is Rishika, and I will be co-hosting this podcast along with Mridupal today. And it's great, absolutely amazing to have both of you here. In addition to what Mridupal had to say, I just wanted to say how lovely it was to find out that your paper on antitrust enforcement and big tech was a part of the Stanford Law School's computational antitrust project. We believe that this is an amazing and necessary initiative that has been taken and has the potential to create meaningful impact in the sector. I would highly encourage our viewers to read your article, as even a law student with minimal understanding of antitrust or competition law will be able to appreciate the nuances of computational antitrust that you have expressed, because it has been laid down with such great care. That being said, I would like to invite both of you to give us a little bit of insight into the paper and explain to us where you're coming from and how your journey has been till now when it comes to computational antitrust. Thank you so much again for being here.
Well, thanks for having us. I'll let Jay go ahead and talk a little bit about the overall.
Well, I'll start quickly. As the introduction described, I work. I'm losing audio. Ron, are you still speaking?
No.
You're perfectly audible.
Can somebody confirm they can hear me? I'm not sure. I've got a frozen screen.
You're loud and clear.
Yeah.
Is it okay?
Yeah.
So I also
Anyone?
glitched out just a few minutes back.
Yeah, he's back. Okay.
Yeah, so I also glitched out. My router for some reason went down. We are all getting technical glitches today. So if the speakers are not offended, I would very much like to continue with the introduction.
Go ahead.
Thank you.
Go right ahead.
So thank you, sir. Mr. Himes, he has served as the Antitrust Bureau Chief in the New York Attorney General's office for nearly 8 years. He has led significant high-profile antitrust investigations and enforcement actions, the state's principal representative in the marathon negotiations that led to a settlement of the government's 2001 landmark monopolization case. And then this is a very well-known case, in fact, from, I think, all over India and all over the world, against Microsoft and a leader thereafter in the Microsoft judgment enforcement activity. For our next speaker, Mr. Ron Schnell, he's an internet entrepreneur. He is the director of the Berkeley Research Group. He's and perhaps the most incredible thing I've ever read. He started programming in 1975 when he was only 9 years old, and he has gone to program in Fortran on an IBM 360 on punch cards. He went on to learn more than 30 computer languages, working at Bell Laboratories, Sun Microsystems, and IBM on the kernel of their versions of the Unix operating system. He's been a staff at and has performed important research at MIT, New York University, Syracuse, and he's a regular lecturer at Syracuse University. He's also been a C-level executive and VP-level executive at everything from personal services corporations, a multinational S&P 500 company, several technology startups, and a leader of a day-to-day operations of a well-known think tank for the computer industry. We welcome both of you, and we are honored to have you here. Now
Thank you
I
for
would
having
like
us.
to hand over the mic. I'd like to hand over the microphone to hand over the proverbial microphone to Rishika to brief a bit on the Stanford project.
Yes, Smritipal, I just laid it out. We were waiting for you to come back to do proper justice to the background of our speakers here today. But I have given a little bit of insight into the project, and I believe the speakers would now like to give a little bit of insight into their paper. So over to you both. Thank you so much.
Well, I'll start at the Microsoft work. The Microsoft work involved making sure that Microsoft did the things that the court had ordered it to do, and those included affirmative technology disclosures that were made available to the industry. The disclosures related to both application programming interfaces and communications protocols. The API disclosure did not occupy a lot of oversight time, but the communications protocol turned into just a long trek with lots of pits and falls and detours along the way. And it was really a multi-year effort before the technology was good enough to be made available to the industry. I might say that the disclosures on the communications protocol side were heavily overlapping those that the European Commission had also ordered Microsoft to disclose. I think there were a few differences, but they weren't meaningful. We had a huge investment in technology assistance that Ron and his group provided. And the Europeans had really none of that. They had a power to fine Microsoft when they were late in getting the technology available. And I think overall it was really a joint effort between the two jurisdictions to get that information really into a form that the industry could in fact use. Ron, I mean, why don't you add your voice to that?
Sure. Yeah. I mean, I don't believe that when this started, anyone fathomed that it would be such a large amount of work to.
Can you hear me?
Yes. I think Jay's very delayed in his audio, but I don't think anyone knew that it was going to be this much work. In fact, the court and the final judgment only really thought about having 3 people to start with, and those people were called the members, and they were court approved. One of them was Harry Saul, Franklin Fite, and Skip Stritter. Very well-known people in the computer science industry. They brought on a couple of people to help them and realized very quickly that we would need an actual large enterprise to get done what was required to be done by the final judgments in this case, in these cases, I should say. So, I ended up hiring a total of 93 people over 6.5 years in order to mostly get the communications protocol work done. And it involved, very, very highly technical work down to the bit level and things like capturing network traffic at wire speed to programmatically compare it to technical documentation. We did things like instrument Microsoft's test labs in Hyderabad and Pune for example, among other places, in order to do that work. So, I think, I hadn't heard the term computational antitrust, obviously, at the time in 2005, but I think that's what we were doing in some sense. And it seems to me that it's an inevitability that these sort of cases will have some form of computational antitrust in them all the time.
Thanks a lot for that background. And now I think we can move on to our very first question. So the article, as you mentioned, talks a lot about the technical committee's massive impact on Microsoft's services and products and how it was a great success overall. However, such a committee was appointed only after a case was moved against Microsoft. And then the technical committee's involvement ended after the decree expired. But considering how useful such a committee was, do you think that there should be a provision that makes such committees to be involved in big tech companies as a preventative measure before any case can even, any computational antitrust case can even come up against such companies? Whoever would like to go first.
Yeah, I think that's a question for Jay.
I don't have any great expertise responding to that kind of question.
Yeah, I mean, I'll say.
I was going to say I don't have real expertise on that question. It's a question of corporate governance, and whether, as a matter of corporate law, are you not hearing me?
Jay, I think you're just.
Hear you, sir.
I gather
you're just delayed,
you're not
so
hearing
just
me.
keep.
Is that right?
No, you're just delayed, so just keep going, even if you hear someone interrupt you.
No. You can, yes or no, can or can't?
We can hear you.
Yes.
Can't hear me? All right, so there's a lot of latency. You're asking a policy question whether a particular country should have a law that's directed to presumably particular kinds of companies in the digital space, I suppose, and whether there should be some internal corporate body that's designed to look at the competitive implications of that company's activities and have some sort of voice in how those activities are conducted. That's not anything I can speak to from experience, but I think that's the kind of governance you would have to have at a legislative level to create a kind of body that would be intended to establish courses of conduct for digital companies to keep them on a competitive path. I mean, I don't know any jurisdiction that does that, and it would involve obviously heavy involvement through government law in the operations of a company.
I guess I would look at that potentially as a different sort of question. I mean, if a company is under investigation for anti-competitive practices, for example, oftentimes there's a negotiation that goes on prior to an action being filed, right? So I could certainly see something like this happening, without there having to even be a remedy, so to speak. So it could be a akin to a settlement type of thing, where we're not going to file this action against you if you agree to have this monitoring or trustee or monitoring organization ahead of it, and if you do a good job, we won't file this action. So I think to some extent this can be done without legislation. That's just my non-lawyer opinion.
Yes, thank you. Thank you both so much. That's precisely what I was looking for. And both of you answered the question in a satisfactory manner. That it can be looked at, many different ways. And I think we can then go on to the next question. So could any of you tell us about how technical experts are appointed in such cases, apart from the company personnel that are assigned to compliance? Now, is
Yeah.
it safe to have outsiders? Sorry, just one line. Is it safe to have outsiders working closely with the company's projects? So, if you have any remarks to make on the previous question, because I believe there was a delay, please go ahead.
I think maybe we could suggest that Jay disconnect and reconnect to hopefully resolve the latency
In the
issue.
Microsoft case, the appointment process involved the enforcer side, the Department of Justice and the states selecting an individual. Microsoft selected an individual. Those two selected.
Okay. Maybe that's going to help. We'll see. I'll finish answering the question. So Microsoft selected a man named Franklin Fite, who had previously worked at Microsoft as an executive and was very well known in the industry. The Department of Justice selected Dr. Harry Saul, who was a tech entrepreneur, very well known for his work with Network General, founding Network General, and then selling it. And the two of them together appointed or selected Skip Stritter, who was also well known for having been an early person at Apple and founding the MIPS corporation that made CPUs. And the three of them were given power by the court to bring on additional staff, which is how I got involved. And in terms of whether it's safe, I'll just add that we were none of the technical committee, that the members themselves or the staff were permitted to testify. So we were disallowed to testify. So that gave Microsoft comfort in allowing us to have access to everything and every person within the company without having to worry that we would later testify. What we reported to the Department of Justice and a couple dozen states about our findings, and they of course were able to talk to the court.
Yeah, that was a pretty unique structure. And the selection process was really modeled after how an arbitration tribunal might be created, where you have a multi-member tribunal. And I don't know of any situation where it's since been used in a litigation context or settlement context. In your more common monitoring situation, there'll generally be only one monitor, and the Department of Justice would select that person, file papers with the court to have the court appoint that person. That was how I was appointed the monitor in the Bizarre Voice case. That's far more common.
All right. So it seems like the court's decree in each case varies depending upon the nature of the violation. So this decree, as you mentioned in your paper, can be quite unexpected and not something that the company would have actually planned for. So is there any way to then make such compliance obligations uniform so the companies can have some idea of what is expected out of them? Or is this never going to be a possibility considering how technology always keeps evolving and sometimes our laws do get stuck up behind them?
Well, I think that the nature of the court-ordered obligations is going to depend on what the competition violation is determined to be. And then starting from there, you have to decide, number one, how you can remedy the violation that has occurred, how you can prevent it from occurring again, and what sort of remedial measures are needed to try to recapture competition lost. And that's a pretty case-specific sort of inquiry, so that I think it's not a likely path that you can identify in advance um, what you might need to do. Now, if you're negotiating a settlement and you're a government enforcer, you have an idea about what violation you expect to prove. Certainly, you can have positions on a settlement going into the case on what you would like to see. And if you can settle the case without active litigation, then the company would know, what it's going to be subject to. Certainly, in the case of Microsoft, there was no remedy. Well, you had a liability trial first, and Microsoft was held liable for doing some things but not others. And the decree was then negotiated between the parties. It was also partially litigated by a group of states that added a few provisions, probably not having a material impact. And that's how you came to the remedies that were chosen. Bizarre Voice was a totally negotiated decree also after a liability determination. And they didn't know going in, certainly, exactly what sort of remedy might come out of the case if they were found liable. I think that's pretty hard to do unless you're going to negotiate a settlement.
Yeah, and I would also add, your question, Mr. Powell, about the law being behind the technology is an important one. I think that we even saw this in the Microsoft case where we had to ensure Microsoft was documenting communications protocols that hadn't been used in 10 years, right? And there were things about instant messenger and things that weren't relevant anymore, and there were parts of the final judgments excuse me, that took into account competitors that literally didn't exist anymore, and didn't take into account important ones like Google, right? In my opinion, Google was the most important competition to Microsoft, and their whole goal was to make the desktop operating system irrelevant and make everything be on the web. And certainly the final judgments in these cases didn't take that into account at all. And I think that's one area where hopefully computational antitrust and things like that can play a role, right? And try to anticipate the fact that this stuff is ever changing, and maybe by automating things you can account for that.
Precisely. Thank you so much. And you're right. Like, maybe as more such cases come up, we will be able to observe certain patterns that might come in handy. But right now, as you said, I think things are quite unpredictable. But hopefully, the law will be able to catch up someday. That being said, our next question is about we would like to ask you what you think is the most appropriate and most logical dispute resolution mechanism for antitrust remedial cases.
Well, I think litigation certainly in the U.S. takes an extended period of time. The judge in the Microsoft case pushed the case fairly quickly, so that it was actually tried and appealed within a much shorter time than you would typically see, but that was still 3 years or nearly 3 years, and that was fast. Bizarre Voice, I think, was a couple of years as well, but that was a much simpler case. It was a merger case, and so I say simpler in the sense that you were litigating whether the acquisition was a violation of U.S. law. Those things, those cases don't proceed that quickly. In other jurisdictions, you have administrative remedies in which the enforcer can determine the violation and impose the fine. But even then, the investigations take a considerable period of time. I think there's some feeling today that a specific regulator might be able to establish standards of conduct that could result in faster enforcement action. The UK is proceeding to set up its own digital enforcer with that view in mind. And I guess that's an experiment that remains to be seen. Certainly, establishing a code of conduct, for example, is a time-consuming task in itself, and in the United States would be subject to potential court intervention to determine the validity of any rules. That would certainly slow up any implementation. If you could put a code of conduct in place and then enforce it, the theory, I think, is that a regulatory enforcer could proceed more quickly than a judicial lawsuit would otherwise proceed.
And I think that the technical committee had a sort of a built-in alternative dispute resolution to it. And we had the ability to inform Microsoft if anyone was claiming any issues, and they had a right to cure it before it got to the court, for further action if necessary.
Yeah. Let me say, if you're talking about as well what you do when the decree has been ordered and the company is under oversight, and there's a dispute between the company and the monitors about what needs to be done, I do think that you can institute resolution proceedings that will deal with that pretty promptly. I know that in Bizarre Voice, we had the company under oversight, but we also had the entity that bought the divested assets talking to us about the compliance that they were getting. So we had two sides that could either agree on things or find problems. And if they had disputes, then they could certainly come to the monitor, who was me. And I had my own process for how to deal with that. And I think that when we had disputes that did exist like that, we could get them resolved really quite quickly. Whoever lost basically would have resort to the court to review a determination of the monitor. And I think for disputes that arise within a remedial decree itself, that's quite feasible and doesn't have to take a lot of time.
No, no. So, then what is the effect of an antitrust remedial decree on a certain company's executive? So, and does it have a positive or a negative connotation on them?
Ron, what do you think?
Well, I think obviously it depends. I can't talk about what Microsoft, thought or said or anything like that. But in my personal opinion, I thought this particular um, antitrust remedy was in some ways helpful to them, and they did say in public that the documentation of their communications protocols was helpful to them. Because it wasn't something that they had completely done before. So that was great to hear at the time. I'm sure if I were them, there would have been. I mean, there were parts of the final judgments that I would consider to be punitive and not, couldn't possibly be looked at as helpful to them. Things that prohibited them from making money in certain areas, right? So certainly, I doubt that they would have thought that was helpful. But there can be areas that are helpful, like this documentation that was required of their communications protocols.
Yeah, I think that companies are not likely to be happy with oversight like that in either Microsoft or Bazaar Voice. They may well try to project a happy face, both with the monitors and certainly with the court, because they don't want to appear recalcitrant or obstructive. But monitoring has an intrusive quality to it, and I understand that it's not going to be met with really open arms by the company subject to monitoring, even though they will certainly profess cooperation. And they certainly do not want to be brought before the court in circumstances where they can be shown uncooperative or obstructionist. I mean, that's certainly the worst position to be in, but it could happen, and that's their ultimate risk. In an ordinary decree, even without monitoring, if the enforcers find that a company hasn't lived up to the obligations imposed, the enforcers will go back to court. That happened in a relatively recent antitrust case in the United States, where penalties did have to be imposed and changes had to be made. So it's not a happy prospect for the company, and I think that realistically, this is not the kind of scrutiny that any company is going to like. They'll, if they're antitrust violators, they just have to deal with it.
You're right. I doubt they would like to see it as a necessary evil, monitoring. But hopefully, the perception will change. Obviously, it'll be difficult for company executives. But yeah, so moving on to our next question. I would like to know if we will see a rise in antitrust remedial decrees in the future. Since technology is advancing every day, wouldn't it ultimately be a bigger hindrance in the future?
Ron, you want to go?
Oh, that's your specialty. You're the big thinker in terms of antitrust
I don't know
trends. And
I don't know if I'm a big thinker. Look, certainly if you're talking about the digital space, and we're dealing, with practices that have some parallels in the brick and mortar world, but not always perfect parallels. Things happen in the digital space that are, I think, different in kind from those in the brick and mortar space. So, and there's more potential for commercial activity to change the way in which things have historically been done. The application of antitrust to that activity is increasingly challenging, and how to remedy violations that may be found are going to be increasingly intricate and require technical expertise, I believe, more and more. You will find that the oversight does indeed have to take place at a very granular level. It may indeed have to take place over a very, on a real-time basis, in effect. And I do think about the Bazaar Voice situation, and while there's a protective order covering the details of the monitoring itself, in broad brush overview, that's public. Bazaar Voice, in selling off the competitive assets that it unlawfully acquired, had to make. This is a company that was doing online ratings and reviews, the kind of product reviews that are familiar on the web, and the star ratings and that sort of thing. It was providing the software for both manufacturers and their customers to get that sort of customer feedback, and acquired its main rival in doing the same thing. It was called Power Reviews, and the acquisition was held unlawful. So the court said, well, you're going to have to sell Power Reviews again, which it did. And then the court said, your Power Reviews is going to be starting from scratch now to build a business. So in order to help gain eyeballs, essentially, for any reviews that customers may post on websites that Power Reviews is providing the software for, well, that content has to be sent to Bazaar Voice, which already had an existing network. And the idea was then the reviews would get visibility. Manufacturers would be able to engage Power Reviews and get product reviews that would have visibility. And that process would take place for a 4-year time period in order to jumpstart the new competitive company. So you had an ongoing business relationship that had to be implemented on a real-time basis, and the potential for disagreement there is quite great, and the monitoring has to be able to react quickly, because the whole concept of the remedy is that it will happen fast. Content will be inputted by a product customer, and it will go from Power Reviews over to Bazaar Voice and get displayed publicly. There were non-discrimination principles there that said, in essence, Bazaar Voice, you're generating your own content. You can't favor it over the content you receive from Power Reviews. So you can see here, a flow of information going on 24/7 that has to run and has to work. And you need oversight that is going to occur at that kind of level to make sure that the remedy is working. And that's a relatively intricate kind of remedy. It's far different than anything we did really in Microsoft, but it illustrates the sort of the fact that we're going to have to adapt remedies to the conduct we find, and in all likelihood deal with the remedies at a very granular level, using technical people to make sure that the remedies are working the way they're intended to work, and if they aren't, to solve whatever problem exists on a fairly quick basis.
Yeah, I guess I misunderstood your question, Rishika. I thought you were asking about antitrust actions in general. I didn't realize it was a technical antitrust question. So I agree with Jay. And I did notice, during my time with the technical committee, we were through, I think, 3 presidential administrations here in the U.S. and anecdotally, I did notice, trends and changes that happen through the administration. So I think maybe part of the answer to your question is it depends on what's going on with the regulatory agencies as well.
So, Rishika, I would like to go forth with the last question then, last but not least.
Yes, Pratitwal, go ahead, please.
No, I think you should go ahead with this one because, like, you're debuting here, so please go ahead.
All right, will do. Just 1 second. And I would just like to quickly address that I really appreciate the quick summary that you gave, Mr. Himes, on the case of power reviews and Bazaar Voice, which is explained really well in the paper as well. So thanks a lot for that. Definitely helped in understanding this answer better. So last but not the least, what is your opinion on the relation between technological advancement and effective antitrust remedies? We've seen that there are several challenges in the above scenarios. What can we do to curb such challenges?
There are a lot of people around the globe trying to answer that question, and I don't think there's any magic remedy, but the power that's developed in the digital space in a few companies, I think, is being recognized globally as quite significant. And I think that we will see a more regulatory approach that permits intervention on different terms than we see today, that basically allows intervention more easily than we're seeing today under typical competition law. And that's going to reflect a felt concern that we have very large aggregations of economic power, which in turn translates oftentimes into political power, and that there is a felt need that existing mechanisms are not responding as well as we would optimally like. I don't know that I can be much more specific than that. I don't know. I think you will see increased regulatory environments. I think would not be surprising to see a new regulatory effort set up comparable to that you do have in the UK. And Europe, of course, has its Digital Markets Act and its Digital Services Act, which are specific attempts to deal with these issues. The US has a whole host of bills in Congress, I think 6 of which were marked up and approved by a House subcommittee last week. They will now go to the floor of the House, and if they can be approved there, to the Senate. But none of them are as far-reaching, I think, as say the Digital Marketing Act and the Digital Services Act in the EU. But they involve very comprehensive changes in different parts of the antitrust law. Ron?
Yeah, I don't have anything to add to that excellent summary.
All right then. So this has been really interesting. Um, I would really like to ask one additional question. That is, what do you think, like the decades to come and the years to come, and the developments to come and the technologies to come forth? What do you think is going to be the implication of antitrust on private equity and venture capital markets?
I'm sorry, the implications of what? The last part I
Any
missed.
antitrust regulations that might come in, any international instruments that might come in, or any technologies that might come in, which might cause the regulations that are in place now to fall a big bit behind.
Yeah, he's asking, how it might impact venture capital or private equity investment.
Well, that's I think that's hard to say. Insofar as the changes make the digital space more attractive, you may see increased startups and need for venture capital at a startup level. There's been some concern, I think, in the U.S. that the level of startups in the U.S. has declined significantly in recent years, and if you can jumpstart that again, then private equity and venture capital is going to be needed, and at appropriate risk levels, I think the money will be there. I don't think if you're talking about the major platforms, I don't think private equity is really going to be much of a concern for them. They're going to have their funding either internally because they're all generating heavy revenue, or the traditional capital markets are going to be available. And so the real question is, can you develop a startup base that will tap into venture capital at higher rates of return?
I think in my experience, whenever you have the threat of regulation, it puts downward pressure on valuation of tech companies. So this is sort of from the opposite side. If these antitrust regulations inspire more startups, that's great. But in terms of investing in those startups, are you worried that these startups are now going to become regulated? So the question is, how much downward pressure does that put on valuations of companies, and what does that mean? But I would also argue that if you suspect that this company is going to be big enough to potentially become an abusive monopoly, it's probably worth enough that you want to be involved. You want to invest in that company as quickly as possible.
All right. So this has been a great session, and I have loved this, and I believe Rishika has loved this, and I believe that all of us, our listeners, our viewers, have loved this as well. I really hope that we can have you guys again here, and I apologize. I most humbly apologize for the network connectivity issues that I've been having and that we have all been facing. So to the listeners, to the audience, we are going to be back in the next episode, probably with quantum computing. Till then, Godspeed, farewell.
Thanks for having
And
us.
thank you.
Thank you. I
Thank
was
you so
pleased to
much.
be able to contribute. Be well.